Okay, folks, I'm just making sure that this is recording. Good evening. Tonight we're going to learn about leasehold estates, or non-freehold estates, as it's phrased in the book. And for those that are in the class, you're going to have a book. It's chapter 4. And inside chapter 4, we're going to talk about non-freehold estates or leasehold estates, types of leases. That's what it comes down to. And we're going to make sure this is recording. And it is recording, apparently. So this is all good. So, good evening. So what is a non-freehold estate? Well, with a non-freehold estate, we have an owner of a piece of real estate, and that owner does not convey or give up title to the property. So that's the difference between a freehold estate and a non-freehold estate. A freehold estate is talking about title. A non-freehold estate is talking about the rights, but not giving up title. And typically in this scenario, the property owner is going to give up the right of possession, all right, and the right of use. So, as it says in the book here, this is our outline for the book. And for those that don't have the book, it's okay. We're going to learn about leases tonight. And I hope you stay with me on this. So, an owner keeps most of the rights, but conveys the right of possession, okay? And it's conveyed through a lease. And the lease is the contract that is formed, and the consideration in this contract is called the rent. So these are all pretty common terms. So we have a landlord, which is also referred to as the lessor. The person that's, or the party that's giving the right is the OR word, lessor. The person receiving the rights is a lessee. That's usually the tenant, right? The person receiving the rights, the EE word, as I say. Duration of time is the term, and the property is leased or demised. So now we have those basic terms out of the way. What are the types of leasehold estates? All right. So the types of leasehold estates are going to be a little complicated at first because it's kind of new, right? You just think of a lease as being a lease. But the types of estates that are given through a lease are what we're talking about. So you have a lease, and what are your rights that you're going to receive? Well, the first type of a leasehold estate is a tenancy for years. Okay, and so a tenancy for years is the definition down here. Okay, it's for a specific period of time. So in your lease, it's going to say the term is going to start December 1st, 2019, and end in November 30th, 2020. All right, it'll be for a year basically. But the difference here with a tenancy for years is that there is a specific end date. And that's how you're going to make your determination here when you're being asked a question about a lease. What type of a lease is it? If it has a specific end date, a termination date, then it's going to be phrased a tenancy for years. Now, as opposed to the next one, which is a tenancy from period to period. Tenancy from period to period will be for any period of time, but it's usually month to month, as it says here. And it usually has an automatic renewal clause. So in other words, it doesn't have a specific end date in there. And there's your difference between a tenancy or a tenancy for years and a tenancy from period to period. Now, what's the other type of leasehold estate that we have? We have a tenancy at will, which is we're going kind of down the food chain now. This is a weaker form of tenancy that you're going to have because it doesn't necessarily have to be in writing. You know, a tenancy that's in writing has more strength, let's say, than a tenancy that is not in writing. So a tenancy at will, in many occasions, is not in writing. And that's going to be a lot of your residential situations, right? Tenancy for years is going to be mostly in a commercial setting because it's going to stretch on for, presumably, right, more than a year. But when you're talking about tenancy from period to period and a tenancy at will, now you can talk about either a commercial setting or a residential setting, all right? The residential setting is going to be from year to year for the most part, and it might have a renewal clause in there, an automatic renewal clause in there. Or it might be a tenancy at will where it might not be in writing at all. A lot of people have that. So Tenancy will, either party may terminate by giving proper notice to the other. Okay, proper notice is usually the period of time in between rental payments. So if you pay your rent on the first of the month, then the duration or the proper notice that can be given to terminate this type of a tenancy has to be 30 days. If you pay the first of every month, it's 30-day period. So your notice has to be 30 days. That's the reason why, in a residential setting, you'll hear you have to give a 30-day notice. So what I usually will say to the class at this point is, okay, so if I want to leave, if I'm on a tenancy at will, and I want to leave, I'm a tenant, and I want to leave, or I'm a landlord, and I want the tenant to leave the next month, and let's say today is the 10th of August, when is the notice to terminate effective? And a lot of times the class will say, well, the notice to terminate will be, if this is August the 1st, it'll be August the 10th, it'll be September the 10th. And it's actually incorrect. And I do that to trick the class usually. The term, or the when the notice becomes effective for the notice to terminate, it's going to be 30 days after the next pay period. So in our scenario, we want to give a notice to either party to be out in 30 days, and it's August the 10th. Well, you've got to go to September the 1st. That's your next pay date, and 30 days out from the next pay date. So October the 1st is when that notice is going to be effective. Okay, so that's what the notice portion is all about. And then the last type of a leasehold estate is a tenancy at sufferance. And this is basically going to happen when a lease term ends. So let's say you have a lease for a year, right? And it's going to end, let's call it December the 31st, okay, of any given year. And prior to that December 31st date coming, the landlord gives the tenant notice that the landlord wants the tenant out. Once that notice is served on the tenant, if the tenant stays longer than the end of the term, longer than after December the 31st, then they're phrased a tenancy or a tenant at sufferance. And that's the lowest form of leasehold estate that a person can receive, because basically all you have is the right to be there. And the way the law is written is you're really not even technically entitled to any type of notice moving forward. Although the state of Massachusetts being so liberal, they do have a tendency to treat a tenant at sufferance as a tenant at will up until the point you reach the judge. But for the most part, the tenant at sufferance is the lowest form of leasehold estate, and they have no rights typically other than the right to possession to be there. All right, so those are our types of leasehold estates. Now we're going to go into what are the types of leases that are out there. So the first lease that we're going to talk about is a gross lease. And so the gross lease basically is the best type of a lease that a tenant can have, right? Because all the tenant does in this particular scenario is pay their flat rent, and they don't pay any of the excess expenses associated with the building. So they pay their rent and they move on to the next month, right? And there's no extra expenses associated with it. So as it says here on the outline, right here, a gross lease or a flat or straight lease, the tenant pays the landlord a specific rent, and the landlord is responsible to pay everything else in association with the building. Okay, what's the next type of lease? We've got a net lease. Now, the gross lease is what you're going to see usually in a residential setting, right? Because the tenant pays the rent, the landlord handles the expenses. You can also have a gross lease in a commercial setting as well. A net lease, now you're kind of getting into the commercial realm, because what's going to happen is the tenant's going to pay, as it says here in the outline, the tenant's going to pay their rent, and then they're going to pay some of the other expenses associated with the building on top of their rent. And so, as it says in your book, when you're looking in Chapter 4, so when you're looking in Chapter 4, a net lease, they say, well, typically you'll have a net lease in a commercial setting. That means that the tenant pays their flat rent, and then on top of that, they're going to pay their proportionate share for insurance on the common areas of the building, their proportionate share of real estate taxes on the building, and their proportionate share of maintenance on the building. And those are all calculated in accordance with the yearly expenses on the building. So it's called a triple net lease. Triple net lease is where the tenant will be paying the rent, the monthly rent, and then all three expenses associated with the common areas of the building. And this is typically calculated by square footage. So what you normally will do in this scenario is you take your entire square footage of usable space in the building, and then you take the space that the tenant is occupying, you put the space that the tenant is occupying over the amount of the total square footage in your equation, you divide, and that's going to be the proportionate share that the tenant normally will pay of those three expenses of the building. So that's a triple net lease. Okay. The next type of a lease we've got is a percentage lease. A percentage lease calls for the rent to be calculated on a certain percentage of the gross sales of the tenant. So in this particular lease, what's going to happen is the lease might say, well, the tenant's going to be making some profits from using our space. And so as soon as the tenant hits the mark in gross sales, in my experience, it's usually been $75,000 to $100,000. Once the tenant hits that in gross sales, there's a percentage over that amount that the tenant must pay to the landlord moving forward of their gross sales. And I had this experience once with a Walmart lease. I had a client that was leasing some space in a Walmart, and Walmart said, well, you're using our name and for your business, and so you can make the first $75,000 of gross profit and use it towards your business. Anything over that, you're paying us a percentage of your gross profit. So that's a percentage lease. And then the next type of lease we're going to talk about is the graduated lease, okay, or the step-up lease. And just this particular lease will increase the rent gradually over a period of time. And the reason behind it usually is the landlord wants to give the tenant the ability to start the business and get established. And then as time goes on, the rent is going to increase because now, presumably, the tenant is doing better with their business. So now, what I usually will say to the class at this point is, we've got these types of leases that are out there. Now, can you have one lease that might be graduated, right? Down here. It could be a percentage. Could it have a percentage provision in there? Could it be a triple net lease? Well, yes, the answer is yes. You could have one lease, and I've seen them, where you have all of these components involved. And so you could have a lease, for instance, that will say, oh, the tenant's going to pay a flat rent of X amount of dollars, and then they're going to pay their proportionate share of taxes, insurance, and maintenance to the building. And then the lease might say, well, as time goes on, the rent will go up. And so if it's a 10-year lease, the first 2 years, the tenant might be locked in at one rent. And then after that, the rent will increase. So there's your graduated provision, right? Graduated, we're not on a percentage, graduated provision. And then if it's in a scenario like with my Walmart example, the lease might have a clause in it that says, oh, and by the way, when the tenant makes more than $75,000 gross profit, the tenant will pay us a percentage of that amount above $75,000, in addition to all the other expenses that we have put inside our lease. So the long and short of it is the lease can have all of these provisions inside. All right, so we just learned the types of leases that are out there. This is all in Chapter 4. For those that have the book, it would be 4-4. Now, what else? There are additional types of leases, okay? And the book will go into those. There's index lease that increases or decreases based upon some index that the parties agree on. Usually it's like the Wall Street Journal type of a thing. There's a ground lease. And with a ground lease, I've come across this a couple of times. With a ground lease, the parcel of land, so the lot that the property that the building sits on, is owned by one entity, and then the building is owned by another entity. And so what will happen is you'll have a ground lease, a ground lessor and a ground lessee, and the person building the building will be a tenant. And they'll own the building, and they'll have a right to a long-term lease on the parcel of land. If you think about it, you're building a building there, you better have a long-term lease there. And when it comes to leases, usually your long-term leases will be 99 years, because if you spill over, as we're going to see, if you spill over with a lease into the 100-year realm, title rights are given away by the landlord. So the landlord doesn't want to go that far. Usually it's a 99-year lease. The tenant is the one that's going to build the building there and conduct business, and the ground is owned by another entity. And then you have a lease purchase, where the lessor and lessee enter into an agreement to rent for a period of time. Then the lessor, the landlord, will transfer ownership to the lessee. All right, and we're going to talk about that in this segment or another segment, depending on how far we get tonight. Then there's a sandwich lease, and that usually comes into a sublease situation where you have a tenant on one side, you have the landlord on the other, and then you have a sub-lessee that comes into the middle and takes a portion of time or space in the lease and kind of gets sandwiched in between the two parties. And the last one we have here in the book is a sale with a lease back, which is, let's say, for instance, we own a business and this space is our space. And we say, well, we want to raise some capital. So let's sell our business, let's sell our space, with the clause inside our purchase and sale agreement that will say that we have the ability to rent our space back. So we own this area, this building that we're in. We're going to sell it, but inside our purchase and sale, we're going to have a commercial lease that we're going to lease it back. So we sell it, we raise the capital, and then we lease back our own space from the new owner. And so we raise the capital, and now we're paying rent. Hopefully that makes sense. All right, and then we on we go. So the book will talk about obligations of the lessor and the lessee. And so basically the lessor has has more. The landlord has more responsibilities, especially in a residential setting in Massachusetts, than the lessee. The lessor has to ensure quiet enjoyment. So this is the landlord now, has to ensure that the tenant can use the property and not be interrupted, so quiet enjoyment, that the tenant has access to the property, that the property is safe and habitable, and that there are no code violations there. The tenant's responsibility is to make sure that they don't hurt the property or cause waste upon the property that will damage it. The lessor, the landlord, is responsible for maintaining the deposits that the tenant may give. Now, in a residential setting, in Massachusetts, the security deposit law is very, very strict. There are some requirements that you're going to see in the book, Chapter 4, as to what a landlord must do with a security deposit. I'm looking in my version on 4-6. And so basically, in a nutshell, when a landlord takes, in a residential setting, when a landlord takes a security deposit, the landlord must make sure that they give a statement of condition of the property when they take the deposit, that they issue a receipt to the tenant, and the receipt's got to state, among other things, the amount of deposit, where it's going to be deposited, the date that it was taken, the name of the parties. And then once the security deposit is set up, it's got to be set up in a Massachusetts bank under the name of the tenant. And there's got to be a receipt issued to the tenant, once again stating where that deposit is located. And there's got to be interest that's going to be paid to the tenant every year on that deposit amount. So basically, the deposit still say the security deposit stays in the name of the tenant the whole time. So there are some very strict requirements in Massachusetts, and if those requirements are violated by the landlord at first must give back the security deposit, no matter if there's damage on the property or not. And if the violation is really bad, then the tenant can be entitled to triple damages under the security deposit law in Massachusetts, along with attorney's fees and reasonable court fees. So it's pretty strict upon the landlord what must be done with the security deposit. As opposed to the last month's deposit in a residential setting, the last month deposit can be commingled with other deposits. It doesn't have to be in a separate interest-bearing account in Massachusetts. Interest still has to be paid on it, but for the most part, the landlord doesn't have to do all those formalities that they have to do with a security deposit. Okay, so that is some of the beginning stages here of chapter 4. Now, the next segment we'll talk about options. And so what are options? Basically options, and I'm on 4-7. Options on a lease are basically the ability of one party to do something. And if that party does that action, the other party is bound. So there can be an option to extend. And so what we'll say is, for instance, the tenant has the ability to extend this lease for another 10 years, but the tenant must give the landlord written notice 6 months prior to the expiration of the term of their lease in order to receive this option to extend. So what that means to us is if the tenant comes about and they say, okay, I'm going to send a letter to the landlord. It's 6 months before the end of my lease term, my original lease term. I'm going to send a letter to the landlord or an email to the landlord and say, I have every intent on extending my lease. Now, the tenant will have their option. They'll be expressing their right, and they'll be complying with the terms of the lease. And so, therefore, the landlord will be bound. So the option is once one party takes action, the other party is bound. So the tenant took action, they sent the notice within the time frame specified in the lease, and so therefore the landlord is bound. What about an option to buy? All right, there's a couple things here we're going to make a distinction with before I end this segment. An option to buy is basically the parties come to an agreement that the tenant will eventually buy the property. And they specify the terms. They'll specify the amount of the purchase price, the time frame in which the purchase is going to happen. They'll also specify how much of the rent is going to be attributable, right? Because the tenant's going to be there paying rent for a period of time. A portion of that rent's going to go toward the purchase price. And so it'll all be calculated out and all be in writing. And basically, the tenant, once again, will have the option to buy the property at the price specified if they follow the terms of the lease. Once that happens and the tenant takes action, then the landlord's going to be bound to sell that property for what they agreed upon at the very, very beginning of the lease term. Now, as opposed to, I'm going to jump ahead a little bit here, the right of first refusal. Now, with the right of first refusal, once again, the right's usually given to the tenant. But what this one will say, it's a little different from the option to buy. What this one will say is if the landlord puts the property on the market, then and then the landlord gets an offer, the landlord has to present that offer to the tenant. The tenant then has a period of time in which to honor that offer and purchase the property at the offered amount. So they basically jump into the shoes of the person who made the offer. So they have the right of first refusal. The offer has to be presented to the tenant, and then the tenant has a period of time in which to respond to that offer and actually go forward with the purchase of the property. So there's two different things there. The option to buy is a set price and a set term, and all the terms are set, and how much money is being allocated is all set. The right of first refusal is if the property is offered on the open market and an offer comes in, that offer has to be plunked down in front of the tenant, and the tenant has the ability within a time frame to act upon that offer. All right, so those are lease options. One other thing I want to make mention of that's in the outline here is the difference between assignment and sublease. Now, with an assignment of a lease, as you're going to see here, the lessee sells the balance of the term of the use of the premise or the use of the premises. And what I usually say to the classes is, if there's any time left or any space left, then it's going to be a sublease situation. If there's no time or space left on a lease and a new party comes in, then it's an assignment situation. So what do I mean? Well, let's give an example. We're renting this space for a business, and we say, all right, at this point, we're outgrowing this space, and we need to leave this space, but we have a lease in place with our landlord for another 5 years. So let's bring in somebody new that the landlord's going to approve, right? And they're going to take the space and they're going to take over the lease, and we're out of the picture. So there's no time and there's no space left for us. We're out of the picture totally. That's an assignment of lease, as opposed to a sublease. And we'll take the same scenario. We're renting this space. We have another 5 years left. We want to go overseas and cultivate that market for a little while. So we might want to go for 2 years. So we'll bring another tenant in that the landlord would approve, right, for the 2-year period. And at the end of the 2-year period, it's understood that that new tenant is going to leave, and we're going to come back into the picture again for the remaining 3 years because we have 5 years left on our lease. So with that one, there's going to be both time and space left. So we're going to be in the picture still, whether it's time or space, okay? And so that's a sublease situation. Now, same scenario. Let's say we have this space that we're leasing, just to give you the idea of space. We're in the space, and then I want to lease out this corner behind me to a new tenant coming in. I want to sublease it. Well, the tenant is going to be in that corner in back of us, and the landlord's going to approve that tenant, but we're still going to be here in the space. So we have space left. We're still here. It's just we're going to sublease to another tenant to share the space with us. That's a sublease situation because there is space left. We're in the space. So if there's time or space left over, then it's a sublease situation. All right? So that is a lot of the major terms in Chapter 4 that I went over tonight using my outline here. I hope you enjoyed it. I'm going to try to do some other segments for the class. And for those folks that are not in the class, hopefully this was educational. It's just to try to talk about what leases are all about and the rights of leases, tenants, and landlords. All right? And so I thank you for your time, and I will see you in the next segment.